Hello everyone again. I'm back with Eleanor Darcy and Nigel Clayton. Just to introduce those colleagues of mine, Eleanor has been with us for 10 years now. It doesn't seem like that long. She specialises in property and insolvency and does a broad spectrum of the property work. She's here with us to talk about undue influence. And in fact, she tells me that she's been in 2 reported cases on that area. She's going to be joined by Nigel Clayton. Now, Nigel is, an authority on the law of mortgages. He's just finished writing Atkins Court Forms, the volume of that on the law of mortgages. I don't know if he wants to hold that up. He's trying to give us a bit of a plug before for his book. It's like an episode of Wogan when people come on to try and plug their new book. You probably won't, well, I don't know, maybe you will, but he says he's done all the forms actually again, so it's completely rewritten. He's done all the forms. I think it's certainly worth having if you do mortgage litigation. And it's only 480 quid, so a snip. Originally, of course, Nigel started his career with a case called in his first 5 years, CIBC Mortgages in Pitt, which was in fact listed back to back with Barclays Bank and O'Brien. The issue in Pitt being an issue to do with the joint status of the wife as surety. So anyway, I'll let them get on with it. Over to you, Eleanor.
Thanks, Matt. Thanks very much. Well, hello, good afternoon, everyone. Thank you very much for joining us. Yes, 10 years. Wow, time really does fly, especially when you're able to work with such lovely colleagues as Matt and Nigel. So without further ado, let's launch in. Hopefully you can see the screen. I'm not the most technological, but I've shared my screen, so I hope that you can all see it. So we're going to talk today. I'm going to address you in respect of undue influence in the context of mortgage litigation. And there are a few bullet points here as to what we're going to address. It's intended to be a refresher on what we all already know on the law of undue influence. I tend to think as practitioners that when we think of undue influence, we think of Ettridge, Royal Bank of Scotland and Ettridge number 2. And our knowledge of undue influence, unless we delve into that case, probably doesn't go much further than that. All we associate undue influence with is Ettridge. Now I have a copy of Ettridge here. It runs to over 100 pages. And I think for that reason alone, people tend to find the law of undue influence quite inaccessible and quite troublesome and difficult to fathom, really. As I say, they just associate it with Ettridge and that's that. So I'll try and talk you through some of the more salient points, some of the refreshing points, and hopefully we'll be able together to go through those points today. So there, I set out. We're going to talk about what is undue influence, what does need to be proven, how does it work, why does it matter, and some pitfalls and practical pointers, and then hopefully a couple of questions for Nigel for him to answer. So what is it, first of all? Well, it's an equitable doctrine. It was developed by the courts of equity and founded therefore upon the principles of fairness. It may be relied upon as a defence to the enforcement of a mortgage, but it's not limited to that context. And I'm sure many of you will have come across the concept of undue influence in respect of trusts and equity in that jurisdiction, and also most notably in the enforcement of guarantees. It's frequently used as a means to try and apply to set aside a guarantee. So I'm sure that context is as familiar as the concept of mortgage litigation. What do we need to prove? Well, the basic idea there is, as I've set out, that a person shouldn't be held to a transaction if he or she has been induced to enter into it by virtue of some power or trust reposed in another person, which has caused that party to enter into the transaction. We know in the context of mortgage litigation that it frequently arises where a wife is asked to put her share of the family home up as security for her husband's business borrowings. Pausing there for a moment. The concept of husband and wife in respect of undue influence is the traditional concept that the case law, and certainly what's indicated in Ettridge, is that the class of categories aren't closed. So although I refer to husband and wife, it's perfectly possible and indeed absolutely arguable that undue influence applies to other types of relationships and is not limited to that category of husband and wife. But when I refer to husband and wife, I'm only doing that because that's the most frequent context in which we find this argument deployed. Again, what needs to be proven and where does the burden of proof lie? Well, in the usual way, and this is quite clear from Ettridge, the burden of proving undue influence lies with the complainant. So he or she, this is paragraph 13 to 14 of Ettridge, may discharge the burden of proof by proving sufficient facts to give rise to the plea of either actual undue influence, which is few and far between in my experience, or presumed undue influence arising from the relationship between the parties, and again, which is the more usual in husband and wife cases. So that requires proof that there's a relationship of trust and confidence and a transaction which calls for an explanation. Once both of those elements are proven, then the burden of proof shifts to the husband, as it might well be if the wife is alleging undue influence, to rebut the presumption. Okay, so those elements need to be proven, then the burden of proof shifts to the other party. Where do we find the law? Well, as I said at the outset of the seminar and the presentation, we find the applicable law in Ettridge. So that's shorthand for Royal Bank of Scotland and Ettridge number 2. And he described, Lord Nichols, at paragraph 8 of Ettridge, the two forms, two different categories, as it were, of undue influence. First of all, actual undue influence, which is akin very much to the law of duress, so overt acts of improper pressure or coercion, such as unlawful threats. The second category of undue influence is where a party has acquired over another a measure of influence or ascendancy, in respect of which the person who's in the ascendancy then takes unfair advantage. There aren't any specific acts of coercion. So that's paragraph 8 of Ettridge, if you're interested. The case law authorities that we know about that predated Ettridge, so the Aboudi Authority and also Barclays Bank and O'Brien, spoke about what was known as classes of undue influence or categories of undue influence. And those authorities have referred throughout them to two different classes of undue influence. The first, actual undue influence, which, as I say, is similar to duress, involves actual use of oppression or domination. The second class or category is formed around presumed undue influence, where the law presumes that a particular transaction between parties who are in a relationship is a transaction that has arisen because of undue influence. And that second category of presumed undue influence is divided into two subcategories. First of all, where there is a presumption of undue influence because of the very nature of the relationship. So, for example, where there is a relationship of parent and child, solicitor and client, but not husband and wife. And Barclays Bank and O'Brien has confirmed that the relationship of husband and wife doesn't fall into that automatic presumption. So the second subcategory is where the relationship on its particular facts gives rise to the presumption of undue influence. So in that regard, there has to be proof of a relationship of trust and confidence. So proof that the complainant reposed trust and confidence in the other party. In Ettridge, as I set out on this slide, Lord Nichols and the other judges decided that those categories or classes of undue influence weren't particularly helpful descriptive categories, and tried to move away in part from those defined classes into determining effectively that whether undue influence was at play was a matter of fact, turning on the facts of each of the cases, and that really the presumptions were just an evidential tool to assist the courts in trying to decide whether there was a relationship of trust and confidence. My experience, unless Nigel has anything to say to the contrary in due course when we ask him some questions, is that those classes and categories tend to still be applied in practice, because many of the judges have grown up with those authorities of Aboudi and also Barclays Bank and O'Brien, have become familiar with applying those classes and categories, and therefore continue to apply them as a matter of course, even post-Ettridge. So yeah, I still think they're helpful. I personally find them very helpful to try and ascertain, do you fall into actual undue influence? Do you fall into presumed undue influence? And do you fall into one of the subcategories? So a presumed relationship or a relationship of trust and confidence that needs to be proven on the facts. So I still continue to apply them. And as I say, many of the judges still do as well. So how does it work in practice when you're faced with mortgage litigation? And I'm sure many of your hearts sank when you saw the subject matter of this topic, because you probably thought it was quite inaccessible, undue influence in the context of mortgage litigation. Well, that I think is in no small part to the fact that Ettridge is so unwieldy, that actually it's very accessible. It's very fact specific. And it's always helpful in my experience to remind yourself of the applicable legal principles. And as I say here on this slide, it frequently arises in a tripartite situation. So you've got the lender, the mortgagee, you've got the husband as the borrower and the joint mortgagor, and you've got the wife as the joint mortgagor and as surety. And invariably in those contexts, it's the wife who is saying that undue influence has been exercised by her husband over her. Once the facts giving rise to the undue influence have been proven, so whether, for example, by way of actual undue influence or one of the presumed categories of undue influence, then effectively the lender, so the bank, the mortgagee, is put on notice, and it may be affected by actual, imputed, or constructive notice. And most of the authorities that you will come across are cases involving constructive notice, where the lender is deemed to be put on notice as a result of particular facts. And I've set out on this slide and the following slide cases typically giving rise to three different situations. So where a lender is put on constructive notice, for example, where a wife stands as entering into the mortgage simply to provide security over the jointly owned property in respect of the husband's borrowings. So that's a very common scenario. Second and third scenarios are cases where the lender isn't put on constructive notice. So for example, where a wife enters into a joint loan as a joint borrower, there's Nigel's case, you have CIBC mortgages and Pitt. And then thirdly, borderline type cases where the wife might have some interest or involvement with company borrowings, where she operates as a director and or she has a shareholding in the company, and where the wife offers to stand as surety in respect of those debts, the company debts. There's some room for ambiguity there. And it seems to me, based upon Mahon and FBN Bank, that the court is saying, well, each of these scenarios there in borderline cases will very much turn on the facts. So that's not me wimping out. It's simply saying you need to analyse the nature of the particular party's involvement in the company. So if the wife is acting as complainant as to what she did or didn't know about the status of the company's borrowings and so on. How is the presumption rebutted? This, I'm sure, is a point that all of us have come across before. And again, it falls into our probably preconceptions of the knowledge that we have of Ettridge. We know and tend to consider that proof of independent legal advice is enough to demonstrate that the party entering into the transaction entered into it with a free and fully informed decision. And that we know normally is enough to rebut the presumption. But that is slightly too simplistic. Proof of third-party advice, so advice from a solicitor, is one of the factors that the court will take into account. But the weight to be given to that advice, such as whether it was enough to bring home to the complainant the true nature of the transaction that he or she was entering into, is obviously relevant to the issue of what advice that complainant was given by the third party. Normally, as I say, proof that independent legal advice was given from a solicitor or other can be held to bring home to a complainant the exact nature of the transaction that he or she was entering into. But as I say here at the bottom of this slide, a person may understand but still be subject to undue influence. So the proof of independent legal advice isn't in and of itself enough. You need to look at all of the facts of the case and all of the evidence to decide whether the transaction was brought about by undue influence. So it's a relevant factor, but it may or may not be determinative on the facts of the case. Why does it matter? Well, if you're acting for a lender, if you're acting for a bank, and a plea of undue influence is raised, no doubt in a defence and counterclaim to a mortgage possession action, you need to take stock and have regard to what was stated by Lord Nichols at paragraph 54 of Ettridge. And this quotation is very helpful. The furthest a bank can be expected to go is to take reasonable steps to satisfy itself that the wife has had brought home to her in a meaningful way the practical implications of the proposed transaction. What does that mean in practice? What was Lord Nichols driving at? Well, he set out at paragraph 79 onwards of Ettridge. He gave details as to what's come to be known as the Ettridge rules, and he gave further detailed guidance as to the steps a lender should take to protect itself. And that involves a lender communicating directly with the wife to obtain the name of her solicitor, suggesting that she may wish to take independent legal advice, and confirming that that solicitor will have to give a confirmation that he or she has explained the transaction to the wife in full. The lender also has to provide the wife with full financial information so that she and the solicitor can understand the nature of the transaction. If the lender, the bank, believes that the wife may have been misled by her husband or perhaps by someone else, or may not be acting in accordance with her own free will, the bank is obliged to inform the solicitor. And finally, the lender must obtain written confirmation from the solicitor that full advice has been given and that the wife understands the nature of the transaction. So we've been through those in some detail because of the fact that those are the Ettridge rules and come to be applied by lenders up and down the country. I hinted a few moments ago that independent legal advice may not always remove influence. And I've set out here a quotation from Mummery J in Pasticcio, that the participation of a solicitor is not a precaution which is guaranteed to work in every case. The court will need to be satisfied that the advice and explanation by the solicitor was relevant and effective to free the complainant from the effect of the undue influence complained of. So again, it's fact specific, basically. Yes, it's great to have proof of independent legal advice, but was that advice given in an appropriate way to give the complainant full information so that he or she could fully understand the nature of the transaction that they were entering into? If the plea of undue influence succeeds, what effect does that have? And I've set out here 4 points which we should have regard to. First of all, if the proof succeeds, then there'll no doubt be a declaration that the particular loan document or security has been procured by undue influence. And at that stage, the court will no doubt make an order setting aside or rescinding the particular document. That's not all bad news for the lender, though, because the lender can have regard to restitution. So if there has been a benefit to the person who has alleged to be undue influence, then they may be liable to account in restitution, and it may be inequitable, given that this is an equitable doctrine and an equitable remedy, to set aside the particular transaction without restitution being made. In addition to that, of course, the lender will normally still retain an effective equitable charge against the other party's share. So at that stage, the lender might well be able to have recourse to sections 14 and 15 of Tolata to apply for an order for sale. And one of the section 15 factors is whether there is any secured creditor or secured lender which has an interest. So that's still a way in. And also there may be an argument in relation to subrogation. We might have to deal with that at a future talk if Nigel wants to talk on the issue of subrogation, because in and of itself, I'm sure that's a separate topic for another day. What kind of issues and what kind of practical guidance can we give before I ask Nigel a few questions and bring him in? Well, in reality, it becomes very expensive very quickly to run a defence of undue influence. And obviously the complainant has to prove it. So has to prove whether there has been operative undue influence before the presumption moves and switches. And it's costly, it's expensive, and it's time consuming. You also have to prove impropriety. So many people jump in at whether there was independent legal advice, and at that stage, don't actually go back to analyse the nature of the relationship and understand whether effectively the principles of undue influence are made out before you get to the issue of independent legal advice and the lender having been put on notice. From a lender's perspective, well, assuming that you can locate the relevant documents, which in and of itself is quite often a challenge for banks and lenders, but assuming that you can locate the documents, there should really be an Ettridge certificate that the lender can rely upon to rebut the presumption of undue influence and therefore say that the complainant made a free and fully informed decision. But as I say, all is not lost from a lender's perspective. If the plea is made out, there are usually other recourses for a lender by way of example, an order for sale or subrogation. So whilst it might be an argument that rears its head and causes trouble for a lender, it's usually not insurmountable because there are usually other routes in. But I think as a matter of course, one should always decide from a cost-benefit perspective, is it worth it? Is it worth pursuing the plea of undue influence when you're asked to advise, for example, a wife in that tripartite situation? Is it really worth it in the long run, given that usually there is a clause in the lender's security and in the mortgage deed which entitles it to add its costs to the security? So it becomes very, very costly very quickly. Okay, I've got a few questions for Nigel if he's unmuted.
Right, I'm here.
Okay, perfect. I don't know if anyone's been asking any questions because I'm not very technologically savvy, but if there have been, then I'll try and access them and let's see where we get to. Okay, so we've gone through the principles, Nigel. What are some of the key points from a practice perspective?
Good question. I think just firstly, and I think you've gone through a lot of really good points in those previous slides, especially the practical points. I think the obvious point for me to make at the outset is that the scope these days for raising a successful plea of undue influence are now really quite limited. We've had Ettridge, we've had a series of cases before and after. We've also had a lot of forbearance, and you only have to go on the FCA website and see the kind of restraint that's being placed on lenders before they enforce. But undue influence hasn't gone away. And in fact, just this morning, trawling through my email updates, there's another reported case involving undue influence too. So it's still around, and I think lenders will always need to be vigilant to guard against the risk of having defective securities. I think if you're going to run a plea of undue influence, you really need to follow through the principles quite carefully. One key point which I'm frequently asked about or frequently have to advise about is that the mere fact a wife hasn't received independent legal advice is not by itself sufficient. So in what you call, Ellen, the typical three-party cases, that's the lender, the husband stroke borrower, and the wife stroke surety. The wife also needs to prove impropriety by her husband, which very much depends on evidence. And in addition, that the lender is put on constructive notice by failing to obtain a certificate of independent legal advice. That's the Ettridge certificate. And just finally, another practical point, do bear in mind that the quality of the legal advice given by the wife's retained solicitor is usually of no concern to the lender. Ordinarily, that's purely a matter between the wife and the solicitor. It's not an absolute rule. If anything puts the lender on notice, then it may be different. But ordinarily, a lender is largely bulletproof once it ensures the wife has received independent legal advice and it gets back that magical Ettridge certificate.
So, Nigel, sorry to interrupt, but Jeremy Rowland has asked a very pertinent question on this topic, which I've managed to access through my technological expertise. He says, what are your thoughts on the same solicitor or firm advising the husband and wife?
Don't have a problem with that. The cases have confirmed that. I think the question has to be looked at from the perspective of the lender. If the lender is aware of any particular chinks in that arrangement or any risk or susceptibility of the wife to further pressure, then for its own protection, it needs to separate them. And that will add an additional layer of cost. But you know, the Supreme Court and the House of Lords have confirmed that in principle, provided the solicitor accepts the retainer for acting for both, it can be done.
Yeah, that's clear in the authorities, isn't it? That's certainly my understanding of the legal position, that Ettridge says that that's okay, that that's doable. But as you say, I think all of these cases are very fact specific. So whilst you can look at them in the round, you really need to drill down actually if you're advising the husband or wife or indeed the lender as to what's actually gone on. Just because I'm very conscious with one eye on the time, and I'm also conscious that someone else may ask a question, or indeed Jeremy Rowland may ask a follow-up question. Where can we find the law on this, and tell us about your new book, please?
Well, it's a good question. The law is complicated. I think your intro, Eleanor, was spot on, that there's such a massive law out there, the accumulated case law leading to Ettridge. And I think you're quite right to wave Ettridge in the air. I keep it on my desk normally, but do bear in mind that it does, I think, resolve 9 conjoined appeals. So quite a lot of that text deals with the specific facts, but you're going to have Ettridge on your desk for some time to come, I'm afraid. That's going to stay with us. I always turn to 2 leading textbooks. It's Fisher and Lightwood, Law of Mortgages, 15th edition. There's a bit at page 485, I think. McGarry and Wade, Law of Real Property. I'm a fan of McGarry and Wade. They've got a good bit. The current editor, Martin Dixon, who deals with the mortgage bits, is actually a subscriber to my website, believe it or not. But he covers the mortgage stuff. I think for up-to-date practical information, I've got to give this book a plug, Ellen. I'm sorry, this is terrible, but Atkins Court Forms, volume 28.1. For goodness sake, don't buy it. It's £488, but it is available on the LexisNexis license if you can access Atkins Court Forms generally. Bang up to date, full of good stuff on practice procedure law, procedural tables. 122 new forms as well. So it's, as it stands, and it's just been published, it's probably the most up-to-date source of current mortgage litigation practice and procedure. Beyond that, again, a bit of a plug, my own website, www.legalmortgage.co.uk. Completely republished this year with a lot of new text, lots of forms, and lots of monthly updates too, if you want those. So those are the sources, I think. I don't know.
Well, that's all very interesting. I'm very glad that we've got you on board as well as someone who is so knowledgeable about the law of mortgages and also obviously mortgage litigation. Probably part of what I've touched upon today, assuming that I've still got 3 minutes left in which I can say this, is that what we're talking about probably has a large element of overlap with what Nick Taylor has spoken about in terms of possession actions. So what you've gleaned from his talk this morning, which unfortunately I wasn't able to attend to because I had a telephone hearing to court this morning, but what he will have touched upon in terms of possessions and procedure and so on is directly relevant to what we're talking about in respect of mortgage litigation. Whilst it's no doubt a slightly difficult topic to get your head around when you think of mortgage litigation, in practice, actually, it's very straightforward on this topic. And I think, although we all thought that Ettridge had in fact clarified the position on law and meant that the concept of undue influence was much more straightforward, I'm still seeing lots of defences to possession actions where I'm acting for the lenders in respect of undue influence. So it certainly hasn't gone away and still seems to be being raised as a defence to enforcement. Okay, so I think I finished slightly ahead of schedule, which no doubt will be a blessing for you all. Thank you very much for your time today. Shame we can't meet up actually physically in person, but thank you all very much for joining. Thank you, Nigel. Thank you, Matt.
Thank you.